Welcome. Now we're going to move into chapter 3, talking about public sector labor relations, its history in the laws. So the outline for this chapter is to understand public sector's definition, the history of public sector, labor relations, public sector labor laws, public sector unions, in contrasting public and private sector labor relations, and finally, public sector challenges that employees are facing in today's environment. Chapter 3, Public Sector Labor Relations, History and Laws. So overall, the public sector consists of various levels of jurisdiction of governmental units which provide some basic services to the citizens or people who are living in that area. So in chapter 3, just think about how violent some of the labor movement practices over the past has been for the U.S. So it gives you more examples of how the public sector has gotten to where it is today. So one of the most important cases that's talked about quite often is the Memphis Sanitation strike of 1968 by the African American workers. The publicity of this public sector union action caused organizing to skyrocket over the years. This is where Dr. Martin Luther King Jr.'s "I have been to the mountaintop" speech was to the city of Memphis the night before his assassination. So the public sector consists of various jurisdictions in governmental units which provide basic government services. The three levels of government are federal, state, and local. The U.S. government has a federal system of government. So local governments include cities, counties, towns, and villages, and as such entities such as schools, boards, and public utilities. All three levels of government have two roles as it relates to collective bargaining. In the private sector as a creator and protector of collective bargaining rights, and in the public sector as the employer. The federal government is divided into three branches: the legislative, the judicial, and the executive. These branches have the same basic shape and form. A state government is the governing body of one of the 50 states within the United States. So state governments and the federal government are legally dual sovereigns. Dual sovereigns. So the sovereign nature of the government explains why collective bargaining in the public sector differs from the private sector. State governments share power with the federal government, and under the U.S. Constitution, all governmental powers are not granted to the federal government or reserved for the states. All states have a written constitution in a three-branch government model on the U.S. federal government level. The executive branch of every state is headed by an elected governor. For us, it is Governor Ron DeSantis in Florida. In the legislative branch is typically a two-tier legislature made up of the Senate and the House of Representatives. Most states are subdivided into counties, which are considered subsets of state governments and share in the state's sovereignty. States rely primarily on sales and property taxes, but also on grants from the federal government for administering programs such as retirement, unemployment compensation, and other social insurance systems, and fees such as tolls, lottery ticket sales, and income from college tuition. So for local governments, a municipal corporation is the legal term for a local government. A municipal corporation is a political creation of a state that is composed of the citizens of a designated geographic area in which perform certain state functions on a local level. In many local government structures, the legislative body also serves as the executive body directing the day-to-day operation of its activities. Some local governments do separate the executive and legislative duties with a mayor or a chief executive who manages the government. The governing members of the local government are elected by voters who live within the voting boundaries of the municipality. The local body has the power to pass ordinances or local laws. One of the historical movements that you see in terms of labor movement in the public sector, specifically in the United States, is the Memphis Sanitation strike. This is where African American sanitation workers went on strike in order to be paid minimum wages. So they were not getting paid minimum wage according to federal law, so they went on strike to get paid at least at the minimum wage level. So this is where you see that Dr. Martin Luther King was involved and gave his final speech before he was killed. The public sector consists of various levels in jurisdictions of governmental units which provide basic services to the citizens that they serve or to their constituencies. There are 3 levels of government in the United States. So number 1 is the federal, number 2 state, and then local levels. All 3 levels of government have 2 roles as it relates to collective bargaining. Number 1, in the private sector as creator and protector of collective bargaining rights. And number 2, in the public sector as employer. The federal government is divided into 3 main branches: the legislative branch, the judicial branch, and the executive branch. At the federal government level, again, you have the 3 branches. So Congress, or the legislative branch, passes the laws. The president is the elected chief executive officer and is charged with the faithful execution of those laws. And the Supreme Court and all other federal courts have the judicial authority vested in them by the Constitution to interpret the law. A state government is the governing body of one of the 50 states. State governments and the federal government are legally dual sovereigns. And so dual sovereignty basically means the sharing of governmental power between the federal and the state governments. State governments share power with the federal government, and under the U.S. Constitution, all governmental powers not granted to the federal government are reserved for the states. All states have a written constitution and a 3-branch government that's modeled on the U.S. federal government level. So at the state level, the executive branch of every state is headed by the elected governor. For us, happens to be right now Governor Ron DeSantis in the state of Florida. The legislative branch is the 2-tier bilateral legislature made up of a Senate and a House of Representatives. And the judicial branch is headed by the Supreme Court, which hears appeals from lower state courts. At the local government level, the municipal corporation is the legal term for a local government. A municipal corporation is a political creation of a state that is composed of the citizens of a geographic area in which performs certain state functions on a local level. And states give municipalities the power to create an official governing body, such as a board or a council. In terms of local government, we have a concept called the home rule. So this is a flexible grant of powers from the state to municipalities like the cities, the towns, or metropolis, or the boroughs to determine their own goals without interference from the state legislature or state agencies. The governmental authority most commonly exercised by municipalities is the exercise of what is called the police powers. So the police power is basically the power to enact laws governing health, safety, morals, and even general welfare of the public in the local counties, local towns, local metropolises, or local boroughs. In terms of the history of public sector labor relations, the Pendleton Act created the federal merit system to address the abuses, administered open competitive examinations, protected employees from being fired for political reasons, and provided that Congress set the wages for federal workers. During the 1930s and 1940s, private sector unionization flourished under the protection of the National Labor Relations Act. Unionization grew later and more slowly than the public sector for a number of different reasons. However, unions had less attraction for many public employees because they already enjoyed some of the protections sought by private employees. The nature of government employment was predominantly white collar, while unionization in the 1930s and 1940s was by large a blue collar activity. So white collar employees are those individuals who are considered professionals and they're wearing ties and they go into the office. They do mostly paperwork or strategic thinking for the long term. However, blue-collar workers are those who are actually having a craft, profession, or they're laborers. A legal environment that was highly unfavorable to public employee collective bargaining kept employees at all levels of government from being able to approach government employers and engage in collective bargaining. The Hatch Act, passed in 1939, amended in 1993, limited the political activities of federal employees to shield workers from political pressure and ensured that the resources of the government were not used to favor a political party. So if you're working for the government, you should obviously remain neutral and serve whoever party or whichever party is running the government as elected president and obviously senators and congresspeople. The Sovereignty Doctrine is about the unrestricted and paramount power of the people to govern. In the public sector, this doctrine is presented as a basic reason for not allowing employees to have collective bargaining rights or the right to strike their public employers. So the US president often offers executive orders. So the executive order signed by President John F. Kennedy in 1962 allowed federal employees bargaining representation, forms of employee recognition, and the right to collective bargaining. So all the way from 1871 to 1993, you see a good summary of various laws that impacted employees and workers of the public sector. There is no federal law currently governing the collective bargaining relationship between states and local governments and their employees. Comprehensive laws allow all state and municipal employees to join unions and to collectively bargain with their governmental employer. Targeted collective bargaining laws either grant rights to most state or local employees. Restrictive collective bargaining rights either prohibit public sector collective bargaining or are silent on the subject. Local, county, and municipal governments can adopt collective bargaining laws or, by practice, recognize and bargain with employee organizations. Public sector unions today fall roughly into three categories: associations or fraternities, public sector unions only, and mixed unions. However, many public sector unions have their roots in professional associations and fraternities that developed before widespread public sector collective bargaining began. Collective bargaining in the private sector is largely shaped by market forces. In collective bargaining in the public sector, however, is ultimately shaped by political forces. The core difference: government is not a business. Government is there to protect people regardless of their views or political affiliations. The government's job is to serve everybody. So what are some of the historical events of the labor relations in the public sector for the US? Well, in the early 1800s, citizens were scandalized by the use of party patronage in federal, state, and local governments. This system caused a turnover of government workers on the basis of their political affiliation, not on their ability or dedication. Unfortunately, this system seems to be very prevalent sometimes in the Afghani governments as well, where we tend to hire our friends and relatives and people that we know because the level of trust is higher with those individuals that we know, as opposed to hiring only people who are fully qualified based on their education, based on their experience, based on dedication, based on their level of honesty, and so on. So the US government went through the same process, but eventually they created laws to separate, obviously, family hiring or hiring people based on party affiliations only. In 1883, the US Congress passed what is known as the Pendleton Act, which provided for a bipartisan 3-member civil service commission to draw up and administer competitive examinations to determine the fitness of appointees to federal office. And then we see the push for public sector collective bargaining activities. During the 1930s and 1940s, private sector unionization flourished under the protection of National Labor Relations Act. Unionization grew later and more slowly than the public sector for a number of different reasons. Unions held less attraction for many public employees because they already enjoyed some of the protections that were sought by private employees, like job protection through the civil service system, benefits such as sick and annual leave days, and also the 8-hour workday issue. The nature of government employment was predominantly white collar, whereas unionization in the 1930s and 1940s was by and large a blue collar activity. The Sovereignty Doctrine basically says that in the public sector, governments backed by judicial decisions were able to resist collective bargaining for many years by relying on the Sovereignty Doctrine. Sovereignty is defined as the supreme, absolute, and uncontrollable power by which independent state is governed. The Sovereignty Doctrine requires that governments exercise its power unfettered by any force other than the people, all the people. In other words, voting is the best way to choose all the people. In terms of state and local laws, state legislatures usually cover wages, the hours, the terms of employment and working conditions, and unfair labor practices, and even the right to strike in those cities and states. Today, public sector unions fall roughly into 3 categories: associations or fraternities, public sector only unions, and mixed unions. The National Education Association, otherwise known as NEA, is the largest professional organization in the world with more than 3.2 million members and affiliates in every state, as well as in more than 14,000 communities. A mixed union is a union that represents both public and private sector employees. There are some bargaining differences in the public sector. For example, we have multilateral bargaining. So multilateral bargaining generally refers to negotiations in the public sector where the authority to commit to a collective bargaining agreement may be shared by the executive and legislative branches, and thus 3 parties are involved in negotiations. And we also have the open negotiation laws, or sometimes you may have heard it as sunshine laws. So sunshine laws may require that collective bargaining sessions be open to the public, often thwarting the parties' ability to compromise. So this is where you would have media coverage. So media coverage can be harmful to negotiations, but it is necessary because ultimate decisions rest with the public. So regarding enforcement of collective bargaining rights, the Federal Labor Relations Authority, otherwise known as FLRA, in many state-created labor authorities perform the same role in public sector labor relations as the National Labor Relations Board provides in the private sector. One of the current challenges in the U.S. is privatization. So privatization refers to a process in which governmental employees are replaced with private sector workers through a contract with an outside employer for the purpose of reducing overall costs. Advocates of privatizing government services contend that contracting out public services does many different things, including the following. 1, produces better management of programs by bringing sophisticated cost-cutting techniques. Number 2, it frees public administrators from managing day-to-day operations and allows government to focus on its core activities of serving the people. 3, it provides specialized skills otherwise too costly for government to recruit and hire. 4, privatization reduces capital outlays for facilities and equipment, which enables government to be more flexible in revising programs. 5, privatization motivates Private sector manages to perform well because they are motivated by opportunities for financial gain. So that goes to the idea of capitalism. Number 6, private firms can provide goods and services much better, much faster, and sometimes much cheaper than the government can. Number 8, privatization spurs economic growth by opening new areas of activity for entrepreneurs in the community. And number 9, dispels criticism with government's performance as a provider of services. And finally, addresses concerns over waste, fraud, and abuse. And also, budget deficits require governments to develop new sources of revenue and reduce. However, on the other side, opponents of privatization cite many reasons also for the downside of contracting out public services. Number 1, savings are often illusionary because the cost for government to bid, administer, and monitor the results of outside contractors are not always considered. Number 2, depending on outside contractors for facilities and equipment makes government vulnerable to cost increases because it is unable to step in and provide the service by itself. Number 3, private contractors expect to earn full profit and must also make enough to pay taxes. So in other words, everything costs more when you outsource this to private parties. 4, laying off public employees caused the government employment compensation, a loss of tax revenues, and low employee morale. Number 5, contracting out lowers the quality of services provided because the private contractor's goal is to maximize profits, which often leads to overburdening its employees. Number 6, contracting out means losing in-house expertise required to carry out governmental activities, and it makes oversight of contractors more difficult, again resulting in lower quality of services for the citizens that the government is trying to serve. By the way, also some consider that it's a union busting strategy which is intended to weaken unions by decreasing the number of unionized government employees. Others say it adversely affects women and minorities. And shifts of functions to the private sector may transfer government discretion into the hands of private parties who are motivated by profits. Contracting out to private sector can promote conflict of interest relationships between government employees and the private sector workers. Also, competitive markets can fail, especially if there are too few firms to compete for government contracts. And finally, overseeing outside work creates management challenges for government administrators. So let's summarize this chapter. Do state and local government employees have the same rights as federal employees? Well, employees of state or local governments must look to the state and local laws for their collective bargaining rights. More than 2/3 of the states have enacted legislation granting public sector collective bargaining rights to some groups of public employees. Teachers, police officers, and firefighters are those most commonly granted these rights. Local, county, and municipal governments may also have adopted collective bargaining laws or by practice recognize and bargain with employee organizations. Why is it that federal governments resist collective bargaining? In democracy, the source of that supreme power is the people who have vested their government with rights and responsibilities as caretakers of that power. The Sovereignty Doctrine requires that government exercises power unfettered by any force other than the people, and that again means all of the people. Collective bargaining was traditionally seen as a threat to that Sovereignty Doctrine if government were to share decision-making authority with employees. Obviously, decisions made at the collective bargaining table would affect the way government provides services and the amount that those services would cost the taxpayers. Do the rights and interests of public sector employees differ from the private sector? In general, public employees differ from employees in the private sector because of who they are and what they do. Public employees provide education, police work, firefighting, and sanitation services, plus the maintenance of public improvements. The natures of services provided are such that the private industry is unable or unwilling to offer them. Therefore, a government monopoly is created to offer those services. Many supporters of public sector unions suggest that there are no meaningful differences between public and private sector unions when it comes to collective bargaining. However, there are in fact several fundamental differences, many of which have been pointed out since the inception of public sector collective bargaining. Prior to the rise of public sector unions in the 1960s and 1970s, a number of courts across the nation in the U.S. routinely observed the dissimilarities between public and private sector collective bargaining. For example, Florida's Supreme Court observed in United Teachers of Dade versus Dade County School Board that it would be impractical to require that collective bargaining procedures be identical in the public and private sectors. Myriad distinctions, not just those of procedures, exist between public and private collective bargaining, and many have been noted by the highest courts of several sister states. The conclusion solemnly held until social and political factors led to the rise of public sector unions was that to grant those unions the powerful tool of a strike and collective bargaining was profoundly anti-democratic. More specific examples of different rights and interests can include: A, automatic due deductions is the most common union security provision allowed for public sector employees. So this is a particular provision in public sector employee contracts because it assists the union financially, but it does not require compulsory unionization, which can run afoul of employee rights under civil service or merit services, where an employee can only be discharged for just cause. B, in most cases, the negotiation of wages and fringe benefits is a private sector union's principal function. Public employee unions, however, often find this subject out of their reach. Under the federal statute governing employee rights, the right to collectively bargain is limited to issues concerning conditions of employment. Wages and fringe benefits are excluded from the Act. For most state and municipal employees, a union contract negotiation takes place during or after the respective legislation body has determined an annual budget. Unions may be limited to a negotiation on how the available dollars are to be distributed between classes of employees, or as base wages, fringe benefits, bonuses, and incentive pay. C, or third, the nature of the job performed in the public sector often determines the amount of flexibility available in the negotiation of hours. Police, fire, and other emergency services must operate around the clock 24 hours, 7 days a week, and whenever they're needed. Fourth, the nature of public employment means that working conditions directly affect the provision of service to the public. So therefore, the number of police in a patrol car or firefighters on a fire alarm run is an issue that may be decided at the negotiating table. And finally, under the federal state statute, a grievance procedure must be included in federal contracts. That procedure includes binding arbitration if necessary. State and local government contracts, while containing grievance procedures, frequently stop at advisory arbitration. So how can public sector union use multilateral bargaining to its advantage? Well, multilateral bargaining allows unions to negotiate with the executive until reaching an impasse and then to appeal to the legislative branch for relief. If there is some political differences between the executive and legislative branches, the union can take advantage of that situation to pressure one side or the other for better terms in conditions. Another question is, should the public sector employees be given rights to strike? Well, for many private sector unions, the right to strike is protected by the federal law. The conditions under which a strike can take place may vary, though. For instance, unions that are operating under the Railway Labor Act, like those at airlines, must go through a waiting period once a contract expires before they're allowed to walk off the job. Public sector employees may or may not have the right to strike. It depends on what unions have negotiated with state governments and the state laws that apply to those unions. For example, teachers, police officers, and firefighters in a number of states do not have the right to strike. Even when public sector unions have the right to strike, employers can threaten to fire them if they do not return to work. For example, President Ronald Reagan fired 11,000 air traffic controllers during 1981 after they ignored his order to go back to work. Overall, as you read Chapter 3, you find more and more data that about 12% of the Americans belong to unions. Of that group, about 8% are members of the private sector unions, and 33% of public sector employees are union members. And also keep in mind that for many private sector unions, the right to strike is protected by federal laws. The conditions under which a strike can take place can vary from place to place. Public sector unions may or may not have the right to strike. It depends on what unions have negotiated with the state government and the state laws that apply to those unions. So again, this chapter provided some of the movements or progresses or changes that have been made in the public sector labor unions in the United States. It may not be applicable to our situation in Afghanistan, but nonetheless, some of the topics are interesting, and perhaps the Afghan Constitution has the same exact intentions to protect people, to obviously offer good services to the citizens around the country. So some of the laws might be very similar. On the other hand, if they're not, we can perhaps make some recommendations for changes to the US laws or to the Afghan government laws. Good luck.